When you look at the Kohlberger case, the defense, people ask yourself, what person would not proclaim their innocence? Pre-trial publicity only works against the guilty. When you waive a speedy preliminary hearing, you are waiving a very valuable strategic maneuver. When I look at the cases that I help people on, I go to the website, I pull up the case, look up what doesn't happen in that case. Pretty much 99% of the times, the attorney, whether it's court appointed or paid, has waived that preliminary hearing. I will submit that it depends on the facts. But if the facts are you are innocent, you want to have it. You want to get that preview of that evidence. I'm going to let you listen to one particular attorney who has hit it on the head. No matter what state you are in, the preliminary hearing serves the same purpose. It's no longer a narrative, but evidence. So let's listen to this attorney for a second. And me, Speak Van Holen, the master litigator, will come back and put it in proper context.
So you've been charged with a felony. The arraignment has occurred. You were pled not guilty. You have gone to the readiness conference, and the DA says no deals. That's all there is to it. You're facing a substantial prison term, and they say no deals, and there's no way this case is going to be negotiated out. So the next step in the process is called the preliminary examination or the preliminary hearing. What is it? Well, the preliminary hearing is where you are present, your attorney is present. The district attorney then puts on a case in front of a judge. You actually go into a courtroom. They can either do the preliminary examination in that courtroom that you went to, or they'll send you out to a different department. So it's before a judge, and it allows for the district attorney to put on evidence. They have to call witnesses. There are some differences in a preliminary examination between a trial and a prelim. It's sort of a mini trial, but it's only before a judge, and it's only to establish probable cause that, in fact, a crime has been committed within the jurisdiction, and that you are the person that is likely to have caused that crime or committed that crime. So what happens? Well, they call their witnesses, and certainly your attorney gets to cross-examine them and point out holes in their story. You've obviously reviewed the police report. You kind of know what evidence they have. Now, the difference here is that the prosecution doesn't have to give you all of the evidence before the preliminary hearing, because their burden is just to put on enough evidence to show that the probable cause exists. This is where prosecutors play their game, because they don't always give all of the evidence. They sandbag, they keep things back. And only after the preliminary examination and you're bound over do they have an obligation. Well, take that back. They do have an obligation for the entire case to show any evidence that either proves or disproves that you have committed this crime. But they don't always do it. Certainly not in a timely manner. Certainly not in a manner that I am satisfied with. So they put on this case. Well, one of the differences between a preliminary hearing and a trial is they don't have to bring in witnesses that actually said things in the police report. They can bring in the police officer under a thing we call Proposition 115 and allow the police officer to testify to what a witness told them. I particularly disagree with this. I think if you're going to put on a preliminary hearing and that you're going to put on witnesses, you put on the witnesses that said what they said. But the law is what it is. So Proposition 115 allows them to bring in police officers, and sometimes police officers can even testify as to what the medical examiner found, so they can actually give medical testimony on what the medical examiner found and why that relates to the case. But the purpose of the prelim is threefold. One is it's to poke holes in the district attorney's case to sort of show them that the case isn't as strong as they thought it was going to be. Two, it can be used as a discovery tool. And what that is that there's certain information that might not be in the police report that the officers are going to come out with, or whatever witnesses that are on the stand are going to come out with.
You heard the attorney, but I'm going to take it a little step further. Now check this clip out. It's not long. Bear with me. Anytime something is valuable, you must put time and effort into it. So take the time and look at the completion of the video.
Ms. Doe, it's been represented to me you wish to waive your preliminary hearing. Understand that in this court's opinion, a preliminary hearing is a valuable step in the criminal justice process. It would give you and counsel an opportunity to cross-examine and review any evidence that would ultimately be used to prosecute you. And by waiving the hearing, you're giving up that right. Do you understand that?
Yes.
Since we know that the preliminary hearing, or rather the speedy preliminary hearing for purpose of this video, is a very valuable right, what intelligent, competent attorney will give up such a right without an exchange of getting something in return? Simply because the public is not aware of the exchange doesn't mean it did not occur. Let me put it another way. What competent attorney that has your fiduciary duty in mind will give up an important right without receiving something in return? Now let's explore something. I was talking to J-Rod on a personal phone call a few days ago. We had the discussion concerning the quadruple murders in Idaho. And he stated, in his opinion, that the 911 call does not exist. And I tend to agree. For the sake of the argument, let's say that it don't exist. Of course, they won't release it, and they never will. Let's say it does exist. How would it change the facts in the narrative of the case? In my opinion, if the phone call exists, it would show who actually called and what they actually said. And it would not really comport with what Moscow PD is saying, that they got a call from about an unconscious person, because we know that all four victims allegedly was found together, like 2 + 2 in this area, the third floor and the second floor. So if you walk into the scene, like the Moscow PD said, upon arrival at the scene, in the coroner, it was bloody, it was messy, it was a massacre. Use your intelligence, people. Moscow PD is lying. If you got a call about an unconscious person and the people at the scene can see the blood, I can conclude that the Moscow PD are lying. And so that's my premises. They are lying. People get it confused that when the Supreme Courts, the Supreme Court of the United States say that the police can lie to you, that's somehow justice. No, the Supreme Court of the United States has said that because they promote the corruption. Think about it, people. If you're looking for an assailant, why come to the public with lies asking for their help? Evidently, you think the public was born 2 minutes ago, and perhaps many of them have been born 2 minutes ago. But when I look at the quadruple murders that happened in Idaho, you can put the dots together by listening to the narrative. If a person called in saying one unconscious individual, and y'all saying that when you got to the scene it was gruesome and bloody, as we can see the blood flowing, we can reasonably conclude that the Moscow PD is lying about the 911 call. I will submit and I will bet my life that 911 call would never be released. This brings me to the speedy preliminary hearing. As you know, you don't need discovery at all. As a matter of fact, that speedy preliminary hearing is exactly what you need to get to the discovery. Since we know that Bill Thompson and Taylor are working in concert to keep the public ignorant of the facts, I have concluded that there will be no trial. There will be a plea bargain in which the public won't hear about. This is just one of my alternative theories. Like I said, he will be convicted by a trial or plea bargain. But the reason I am leaning close to a plea bargain is because they are working very hard. They are working harder than an immigrant. And kudos to the immigrants. They work very hard. They hustle very hard. That I know. And I love that hustle. They are working hard to keep the facts private. This indicates that a agreement is being worked out to keep the public blind. See, once this plea bargain is accepted, the people are going to scratch their heads because they don't know the facts. Now, I will submit, I run across an article while I was watching social media 2 days ago dealing with the DNA. Y'all about to find this very interesting. The more and more I thought about how Bill Thompson has pushed to keep the workup of the DNA out, I run across something that I cannot ignore. And I wonder, when the FBI took the STR up, did they run into this particular problem? Let's look at this video. As you can see, in the Angie Dodge case, in which they found her murdered and stabbed and raped in 1996, they went to question everybody that knew her. Christopher Tapp, getting out of high school, a youngster. The DNA did not point to him. But why did they press him for a confession in which he states that they forced him? No evidence. Now, this happened in Idaho, the same state that the Kohlberger case is in. Now, I'm going to tell you something about this case, but let me finish this. The DNA didn't connect it. Nothing connected Christopher Tapp. So, as you can see, the police, according to Christopher Tapp, forced him to confess, even though no corpus delicti was there. In other words, you can confess to a crime, but there must be something to corroborate your confession. As you see, that DNA genealogy workup led to Ursary, I think a film director he was. He was later cleared. Then led to a distant relative of Andy Dodge. And he confessed to the murder and rape. See, the DNA, if it's not scrutinized, people, the experts, the police, the DA, the genealogists can go up in court and tell the courts anything. It makes me wonder why Ann Taylor have never cited this fact in her motions for that genealogy workup. See, people, I study and I'm a student of the law. Her argument would have been more compelling with this case and its facts. She never made this argument. Like I said, people, she's working with the prosecutor. That's just my opinion. That's my analysis of it. I could be wrong. But when the police, the prosecutor, are keeping and hiding the facts and changing the facts, I must theorize. I must give my analysis. But hold up. I went further. See, that video I just showed you about Christopher Tapp didn't tell you everything. So let's get back to the next part of this video. This is about to shock you.
I'm Natalia Hepworth here in Idaho Falls, outside of the Public Defender's Office. We are here to speak with John Thomas, who's been Christopher Tapp's defense attorney. In less than 24 hours, Chris Tapp could be a free man.
So you've been working on this case for a really long time.
Yes.
What does this mean for you? What's the possibility?
It's the culmination of a lot of years of hard work, and it means that someday we will get a free man to... We will get Chris Tapp out of prison, and he will be a free man. And that day is tomorrow. And so we are super excited about it.
Can you tell me the terms that you have in place?
I can tell you the general terms. The judge has kept the stipulation, and he will read that in open court, and then I'll be out in open court. But generally what's going to happen is Chris Tapp is waiving his rights to appeal. He's going to waive his rights to the post-convictions that he has now. We're going to withdraw all of those. And he is going to, the conviction for murder will stand. He's been convicted of murder by a jury. That will stand. He will not allocute. He will not say that he was part of it. He will not say that he was there. Just the conviction will stand. The rape conviction will be vacated and dismissed, so he will not be a sex offender. He has done 20 years and 2 months or whatever it is, over 20 years in prison. His sentence will be reduced from 30 years plus life in prison down to 20 years. and so he will be walking. Hopefully, he'll be walking out of the courtroom a free man tomorrow. Worst case scenario, they may have to take him back to the jail to process him, but we're certainly hoping that the judge will order him released immediately, and that he'll be able to walk out of the courtroom a free man. What we've decided to call it is a resentencing. Basically, Chris Tapp will be resentenced under the post-conviction, under the current post-conviction petition that we have. The judge has jurisdiction under that petition to visit the original conviction that was a 1997 criminal case. And so he's being resentenced in the criminal case under the post-conviction petition. It's kind of a, that's just how they're going to have to do it.
So what has changed in the last month in order to have this result of Chris being released on Wednesday?
Well, you know, it hasn't really been the last month. I mean, we've been getting evidence coming in over the last several years. We had a year and a half ago, we had hand swabs tested from Angie Dodge's hands back in 1996. They were never tested back then. We've recently had those tested. The test came back exactly how I thought it would come back. The killer's DNA is on there. No one else's DNA is on there. We've had new tests done from True Allele, and they have shown that Chris Tapp is absolutely not a contributor to DNA that they found on the sweatpants. DNA they found on the shirt wasn't Chris Tapp's. Chris Tapp was absolutely excluded. Ben Hobbs was absolutely excluded. So there are issues there that have not necessarily been in the last month or so, but they've been creeping along, and we've been pushing them to the surface. And so it's been a long journey, but I think as everybody gets closer to the hearings, everybody looks at their risk assessment and they say, gee, what is the risk of winning? What is the risk of losing? What do we have to lose? And in this particular case, Chris, you know, if we lost at this hearing, he'd be looking at another 10 years before he's parole eligible. And if we won at the hearing, we have a risk of losing at the Court of Appeals level. We have a risk of losing at the Supreme Court level. The state has already indicated that if we were to go through the hearings and they were going to lose, that they were going to appeal. And if we were going to lose, we absolutely would have appealed as well. So there's that risk. And as everybody gets closer to the hearing date, they start, you know, thinking, gee, we need to iron this out. We need to make sure that we're in the best possible position. We both parties had a lot to lose here.
Right. Would you like to add anything else?
Victory.
As you can see, the investigator genealogy workup is always questionable. The Christopher Tapp case clearly demonstrates this particular fact. So the question is, why are the courts going along with the fact that they don't have to give you the workup? See, if you look at the Christopher Tapp case, the DNA led to a guy by the name of Ursary. I believe a producer of screenplays or something like that. They eventually cleared him. Then it led to the real killer, a distant relative. So when you look at the Kohlberger case, when they initially worked that DNA up, if DNA was actually found, this brings me to why the FBI reached out to the private lab and say, hey, we'll take over from here. Could it be that when the police was working up the STR on their end, or whatever they was doing with the DNA, that it led them to somebody in Kohlberger family, and then they said, we'll take it from here? I don't know. But the point I want to make in this video before I close it out is this. And Taylor could have made a serious, plausible argument for the workup of the DNA by citing the Christopher Tapp case. Christopher Tapp always professed his innocence. There was no DNA evidence to link him to the crime. There was absolutely no evidence. He had an alibi. As a matter of fact, he had 2 alibis. Moscow, Idaho police got a few of their friends to lie on him. The jury found them guilty. They had the death penalty on the table, but the judge took it off due to mitigating circumstances, based on the fact that they coerced him in certain statements, etc., his age. Now, this brings me to the Kohlberger case, people. Why would genealogists in a prosecution want to hide the methodology of how they got to a person? They keep citing privacy concerns, but they are not concerned with privacy because they are accessing DNA websites where people have option out of it. What they are trying to hide are their criminal acts and civil violations to keep them from being sued. Now, when you look at the Kohlberger case, in the Christopher Tapp case, there was absolutely no evidence. So if you think Kohlberger will not be convicted, on the day of conviction, on the day of the plea bargain, I will call you a lie. I know he will be convicted. Trust me, people, he the killer. But they trying to hide the methodology of how they got there. He is the killer. For all you screaming about the presumption of innocence, presumption is just like an assumption. It's not a fact. It's like, okay, we don't know. So let me put it like this here. How can you base a presumption of innocence in the same sentence with justice? You can't. Because it's presumed that police will do their job. But every day, 24 hours a day, past case law, past incident, show us that their presumption that the police would do the right thing is an absolutely lie. So remember, people, when you're giving into a presumption, you are giving into a lie. No defendant has the right of the presumption of innocence. No defendant. Let's dispense with this nonsense. You know why? Because if they have the presumption of innocence, you need to look up what the word presumption mean or presume mean. It offers nothing. The only right that a defendant has is due process to adequate representation by their attorney. And if you don't understand what your attorney is doing in real time, you'll be crossed out like Christopher Tapp and go do 20 years before the case is reversed. But let me say this about the Christopher Tapp case that happened in Idaho, in the state of Idaho. The prosecutor, he started filing post-conviction remedies. And they stipulated that the murder case would stay as it is, but the rape case would be dismissed. And they would modify the sentence. Why would you want him to stipulate to a murder that he didn't commit if you seek justice? During this time, he was filing lawsuits that was pending, filing post-conviction remedies. The Court of Appeals affirmed his conviction, but later on down the line, they retested the DNA and etc., untested DNA, and he actually got the murder conviction vacated through an actual innocence. People, the prosecution, states are not concerned with justice. That's a presumption that they are concerned with justice. They'll lie, they'll cheat to convict you. But when you expose them, that's when they start trying to pretend like they're about justice. Because, ladies and gentlemen, I'm here to tell you, if you go back and review the Christopher Tapp case, there is no DNA, there is nothing physically to connect him to the crime. He couldn't even describe the crime correctly. Why did the Idaho police want this man to take the rap? They just it's just business, people. Just like in Moscow, Idaho, it's just business. But in this particular case, Kohlberger is the killer.
All the evidence is there and the facts are there, the circumstances are there. Remember, the death penalty is coming off the table because the judge is going to take it off the table, or the prosecutor. But if the judge take it off, they're going to go with the mitigating circumstances. He was a loner. He was an overachiever. He didn't have a girlfriend. He felt alone, which will all be BS. You go in there and slaughter 4 people. There is nothing to mitigate against that. My name is Speak Van Holden, and I'm signing out.